Bonsoir, and thank you very much for coming. It's a pleasure to be here this evening. Before I begin, I'd like to give thanks to Professor François-Emily, Professor Pierre-Charles Pradier, of course Dr. Amel Makhlouf, and Miss Sophie Guardo, and finally Université Paris 1, Sorbonne Panthéon, for hosting me. I'm very grateful, and it's a pleasure to be able to speak to you. I'm going to speak about the role of context in the transformation of Islamic law and global financial markets. The talk I'm going to speak about derives from my book. I suppose the first question people ask me is, how is it possible, how did you get involved in this subject? In fact, when I show up to my classes to lecture, my students seem surprised that I'm their lecturer. Well, the long story is that my studies led me to study the Middle East and the political economy of the Middle East, as well as the law. And my intellectual curiosity took hold. But really, I came up with Islamic finance because I believe that it offers a very interesting and useful case study for examining the effects of globalization on the legal, economic, and social fields of life. What is Islamic finance? Well, Islamic finance is an asset-backed form of finance. It's premised on the creation of value from the exchange of goods and services, as opposed to the creation of money through the sale of debt, which is generally what the conventional economy is about. So it's about the exchange of tangible, principally tangible goods and services, and the extension of credit in doing so. What are its origins? Its origins, in fact, are ancient. However, they were quite different than what we have today. There's a tradition of Islamic commerce, of course. The Prophet Muhammad was a trader. His closest companions were traders and merchants. The eponyms of the schools of law were themselves traders, jurists, but also traders. And this heavily influences the law. And in fact, the underlying spirit of Islam is it advocates trade, which is distinct in terms of monotheistic religions. And these ancient contracts that we see today are exactly that. They're ancient. In fact, some of them predate Islam by thousands of years. Islam came about and ultimately modified these contracts, filtered them according to Islamic criteria, and used them throughout the classical period. But they used them in a much different way, of course. In a fairly simple economy. In today's global markets, these contracts have become something quite different. But the same underlying structure is there, and the same nomenclature, the same name. Now, Islamic finance is active in more than 70 jurisdictions across the globe. And my book, in fact, explores a number of jurisdictions so that I can do a proper case study and give the reader as well a comparison of how it's undertaken. I study Bahrain, the DIFC, which is the Dubai International Financial Center, and the United Arab Emirates, as well as the United Kingdom. But in particular, I'd like to focus on the development of what I have termed Islamic financial law. What is Islamic financial law? Generally, actually, for the lawyers in the crowd, you might not necessarily associate a particular body of law with Islamic financial law. That's because Islamic financial law is something that is facilitated in a jurisdiction, no matter where that is. There is not a separate body of Islamic financial law. And in fact, that makes it quite interesting, certainly from an academic perspective. Islamic finance is facilitated in the jurisdictions where it is active, and it's also regulated in those jurisdictions. And it's done differently from jurisdiction to jurisdiction. But IFL is an aspect of the development of what I would term global commercial law. And global commercial law is comprised of usages, trade usages, customs, norms, and principles that have at times been described as a lex mercatoria, or a law merchant, a law that is created from commercial practices and ultimately finds its way into the legal structure or into the legal relations of parties, such as the unidroit set of codified laws. These legal norms are international legal norms, and they find their way into international practices. Islamic financial law is an aspect of this global commercial law. It's a global law merchant comprised of international commercial financial principles and customs. What's important to note is that it's a globalized variant of Islamic law. And there's an Islamic aspect to this. It's a very important aspect to it. But it offers many different perspectives on the development of financial markets, including the legal systems that underpin them, and perhaps most importantly, the actors, the states, the regulatory authorities, the sharia scholars, lawyers, bankers, and investors that drive them forward. The transformation of Islamic law and global financial markets represents a history of the dramatic changes that have taken place in the era of modernity and the diverse ways in which Islamic law has been affected. It underscores the enormous challenges of reintroducing the Sharia in commercial and financial affairs of modern Muslim life. So what is the role of the Sharia in today's world? Well, the dismantling of the Sharia and its law-making authority, including its learning and legal infrastructure, which was comprised of learned scholars known as the ulama, and the incubators of learning, the madrasas, in the classical period, this began to be dismantled in the 19th century. And that is the time when a shift between the lawmaking authority of the jurists shifted to the lawmaking authority of the state. So the state assumed that power, and this transformation between the state and jurists replaced the repository of legal authority that had resided with the jurists, and the social prestige and the way in which jurists were embedded in their society. So this was a huge rupture where jurists in a few short years lose the ability actually to decide the law for Islamic polities. This, of course, coincided with the rise of the nation state and the development of European imperialism, which sometimes superimposed European legal codes on Muslim polities, and in this event led to very many interesting examples of what we would call legal pluralism. In India, for example, under the British Empire, a type of law arose that was termed Anglo-Mohammedan law by the Orientalist scholars at the time. But it comprised Islamic law on one hand and English law on the other. English law as the administrative and often criminal law, and Islamic law was left in the realm of family, inheritance, and these sorts of issues. It produced many variants where the laws interacted and in fact developed something completely new. So this is one example. And another example is that many European legal codes were adopted and willingly adopted. And this was particularly the case in the Ottoman Empire at the time, which was the power base of Islamic civilization, if you will. The elites of the Ottoman Empire willingly wanted to dismantle Islamic law and adopt European codes because they felt that was the only way at the time to modernize the empire and to catch up with Europe, whose scientific, military, and economic superiority at the time was encroaching upon Muslim lands, was slowly and subtly dismantling the Ottoman Empire. And so the Ottomans instituted a series of rapid reforms known as the Tanzimat to strengthen their relative position. And this began with civil and criminal law reforms. A commercial code in 1850 was adopted. A penal code, a code of commercial procedure, a code of maritime commerce. All of these were based almost entirely on French law. The last of the Tanzimat reforms, the Majella, was billed as a civil code. It encompassed nearly all areas of private Hanafi Islamic law except family law. It paved the way for a broader effort to codify Islamic law throughout the Muslim world. Codification, in fact, indicated a concerted effort to secularize Islamic law. It was a radical step in the direction of modernity, as the nature of a codified legal system indicated a type and method of justice that was largely foreign to Islamic lands. Islamic law was traditionally a less formal mode of justice. It was a mode of a legal system that was less adversarial and more conciliatory. Codification ushers in a foreign norm, a norm in which legal statements are expressed unequivocally, in as direct and as precise a manner as possible. Those of you who are familiar with Islamic law may know that Islamic law is often discursive. It's often an exhortation, a moral exhortation, or a statement or an opinion, but it is seldom a single statement that says this is lawful and this is unlawful. Whereas codified law changed that. Codified law was a statement of law that produced a sort of binary outcome. And that's it reflects quite a different nature, quite a different legal system. The Majella, some scholars in fact, perhaps dramatically, have termed the introduction of codification as the death of Islamic law. I wouldn't go that far, otherwise I wouldn't be here today. But in some sense, and many scholars agree with this, that traditional system of Islamic law, that did come to an end. The time when Islamic law was the governing legal system of Islamic polities did come to an end in the 19th century. And ever since then, it has been reintroduced, kept in the area of family and inheritance, but reintroduced in other ways. And that is certainly the case in financial markets. The Majella finally gave way to the adoption of legal codes in Turkey in 1926, in Lebanon in 1932, in Syria in 1949. In Iraq, it wasn't until 1953. And remnants of the Majella, in fact, have been retained in the legal systems across the MENA region. Its eventual replacement, however, indicated an almost complete dismantling of the Sharia legal system, and with it the social fabric of lands under Ottoman rule. Well, let's go forward in the future, and now that we have that background, talk a little bit more of what's contemporary. What is the contemporary position of the Sharia in the legal systems of Muslim majority states? Well, it's most present, it's most undistorted in Saudi Arabia, the keeper of the two holy mosques, and in which Saudi declares its constitution, in fact, to be the Sharia, the Quran and the Sunnah. And it has a basic law of governance which comprises the Quran and the Sunnah. But in fact, Saudi Arabia has a parallel body of regulations known as Nizam. And commercial matters are dealt with in banking, companies, intellectual property, and capital markets are all dealt with in modern regulations. Although these are subject to a so-called board of grievances, whose judges are trained in the Hanbali fiqh or positive law, school of law, these disputes are usually resolved by separate specialist dispute resolution bodies outside the jurisdiction of Sharia courts. Other states are more complicated than that. In fact, they are hybrid legal systems. They have often reintroduced Islamic law after a period of having adopted European legal systems, European codes. Iran would be an example of this. Pakistan, Sudan, Afghanistan, the northern states of Nigeria, to some extent Libya. All of these states have re-Islamized their legal systems by introducing Islamic law codes to previously adopted Western systems of law. And you'll notice Islamic law codes is what I've used. So they're using codification of Islamic law. So a completely different nature of Islamic law has been introduced, even in those states. And the position of the Sharia in almost all Muslim majority jurisdictions is not usually dominant or clearly defined, nor is it consistent. Let me give you some examples. The Gulf states' constitutions and legal systems, which comprise civil and common law, are hybrid legal systems most of them are premised on the Egyptian Civil Code, which was promulgated in 1949 by Abd ar-Razzaq as-Sanhuri, and subsequent legal reforms that have taken place in these countries. The Egyptian Code itself is premised on the French Civil Code, as well as elements of Egyptian jurisprudence and Islamic law. The Sharia in these countries is said to be either the source or a source of jurisprudence. But this is in fact contrary to many of the promulgated laws, including those concerning the levying of interest and the use of insurance and derivatives. It also conflicts with various statutes in these legal systems, which indicate a differing rank of legal sources, sometimes based on international legal principles, equity, and of course the codified civil law of the respective jurisdiction. So, for example, the Supreme Court in the UAE, the law enacting the Supreme Court in the UAE, does not list the Sharia as the source of jurisprudence, but a number of different sources of jurisprudence in the event that a judge is unable to solve the conflict on the basis of the law that they have available to them. They have the ability to go to these other sources of jurisprudence to find an aid, if you will. And this results in great legal uncertainty for lawyers who are trying to issue legal opinions on whether or not a certain investment will be considered lawful in a jurisdiction, and concern that a certain transaction will be declared, or aspects of it will be declared invalid as a result of the way in which the Sharia comes to play a role. So legal practitioners, not surprisingly, almost never use the Sharia as the governing law of Islamic financial contracts, unless they choose Saudi law. To my knowledge, the choice of Saudi law in these transactions is very, very seldom, for the reason that Saudi law is a conservative expression of the law. Hanbali fiqh, in commercial terms, is actually known for its liberalism. One of its great jurists is Ibn Taymiyyah, who believed, in fact, in permissibility. That being said, there are many other aspects of Hanbali fiqh that would be considered quite rigid from say, an English law point of view or a French law point of view, and business people are aware of these and quite cautious about using that system of law. And this produces the strange but also actually reasonable choice of English and New York law as being the two dominant legal systems in Islamic financial transactions, and as well in the Gulf states. There are different reasons for this. Clearly, the role that these legal systems play, deriving from the financial centers that they represent, is a big issue. They're a well-developed system of jurisprudence. They're considered objective and predictable, and investors, have a good idea of what they're getting when they structure their transaction based on these legal systems. Another reason is these legal systems' preference for freedom of contract, and the fact that these transactions in fact can be Islamic financial transactions, but will be enforced according to English law or New York law or another type of law. This indicates that that Islamic finance, depends on a secular legal system for its facilitation and regulation, or at least it depends greatly, and it has profited greatly. It has been particularly beneficial to the industry in being facilitated by a secular legal system. The result of this really produces a number of factors. One, that the Islamic legal substance of transactions given effect in modern states' legal systems is significantly altered. Two, a fundamentally changed context after having not been a functioning legal system for well over 150 years sheds light on the reasons for why it is a fundamentally different substance. And three, the reintroduction of Islamic law in a highly globalized world economy subjects the law to a whole host of structural forces that have no classical example and which now determine both the substance and the letter of the law, the substance and the form of the law.